Welcome to This Week in Education Law, Educational Administrator's Guide, where I share up-to-date court decisions from the perspective of educational administrators and policymakers. This is where law meets educational leadership and administration. This is episode 29. In this episode, I focus on a case about workplace retaliation, an issue that hits close to home for many administrators. I'll first introduce the case, followed by actionable practices educational administrators can follow to avoid being accused of retaliation. For those facing the tough end of workplace retaliation, I'll share some strategies to fortify your defense and uphold your rights. The case Kincaid v. Unified School District number 500, 2024 is about the conflicts between an assistant principal and the school principal in the middle school. The assistant principal found herself in a challenging position in February 2019 when she had to respond to complaints about a male special education student's inappropriate behavior towards female students. Initially, the assistant principal documented the incident in an older school database instead of in the school's new database. Moreover, the assistant principal did not discipline the male student and told his guardian that no disciplinary record would be entered unless a second incident occurred. The situation escalated in March with a more serious allegation against the same student. The assistant principal acted promptly, following what she believed to be the correct protocol in the school principal's absence. She reported the incident as sexual assault to the school district's director of student services. The school principal was out of the school building that day, and the assistant principal emailed the school principal about the assault later that day. If you were the school principal, how would you respond? In this case, before the sexual assault incident, the school principal actually had already emailed all assistant principals at the school that he would be taking over the reins for the overmost supervision and evaluation of our special services because his supervisor had expressed concerns about the discipline of special education students, and the school had been under the watch of the state for that end and over suspension of special education students in relation to other populations. The Monday after the sexual assault incident, the school principal emailed the assistant principal the new protocol. Whenever there is an issue with a special ed kid who would potentially be given discipline, please involve me before making any decisions regarding consequences, suspension, etc. 4 days later, the school principal sent the assistant principal a formal letter of concern criticizing how she handled the February incidents. The school principal stated that it was an impropriety to tell male students' guardian that no disciplinary record would be entered unless there was a second incident, and that because the students had significant special needs, it would have been appropriate to address his behaviors immediately following the first incident with more intensive and sustained consequential behavior support than was provided. In the letter of concern, the school principal also criticized the assistant principal's handling of the sexual assault in March. According to the school principal, it was an error on the assistant principal part to have communicated directly with the student services about it rather than speaking with him first, because he should always be informed of any incident that might be escalated beyond the school. The school principal concluded the letter of concern by informing the assistant principal that any future concern of this nature will lead to further disciplinary action up to and including termination of employment. This letter of concern was placed in the assistant principal's personnel file. 2 days after receiving the letter of concern, the assistant principal emailed a written complaint to the school district's Human Resources Department about the school principal's behavior. She claimed that she felt singled out and harassed by the school principal, that it was unfair for the school principal to issue the letter of concern without stating what policy she violated in reporting the sexual assault, and that a reprimand for her handling of the February incident was unwarranted. 1 year later, the assistant principal filed a charge of discrimination with the Equal Employment Opportunity Commission after receiving a right to sue letter in February 2021. She filed a lawsuit alleging retaliation under both Title VII and Title IX. The United States Court of Appeals for the 10th Circuit affirmed the district court's ruling in favor of the school district due to insufficient evidence to show that the school district's reason for the adverse employment actions were a pretext for retaliation. The court focused on 3 main adverse employment actions to determine if they constituted retaliation against the assistant principal: the emails about the fire alarm and 911 calls, the school principal's request for the assistant principal's transfer, and the letter of concern issued by the school principal. Let's look at them one by one. First, the court found that the school principal's emails, which were sent almost a year after the reported sexual assault, asking the assistant principal to inform him about future incidents, were not retaliatory and part of standard administrative expectations. The court believed the nature and content of the emails were not intimidating, threatening, or otherwise discouraging. That is, a typical rational individual in the assistant principal's position would not feel discouraged from coming forward with concerns or reports of discrimination because of those emails. The emails were viewed as routine administrative communication, not as a form of punishment or intimidation for the assistant principal's past action, like reporting the sexual assault. The school principal's emails did not constitute a significant negative change in the assistant principal's employment condition. In legal terms, for an action to be considered retaliatory, it must be materially adverse, meaning it could dissuade an employee from making or supporting a charge of discrimination. The school principal's request for better communication about emergencies would not likely prevent a reasonable employee from reporting discriminatory behavior because it does not worsen their work situation in a significant way. Second, the school principal's request to have the assistant principal transferred from his school building was seen by the court as based on facially non-retaliatory reasons. The court's interpretation of the school principal's transfer request relies on the examination of the motivations and justifications for the action. When an action is described as based on facially non-retaliatory reasons, it means that on the surface, the reasons given for the action do not appear to be driven by a desire to retaliate or punish someone for engaging in protected activity, such as reporting discrimination or misconduct. In this case, the principal cited concerns about communication and trust as the basis for requesting the transfer. This suggests that the principal believed there were substantive work-related issues that impacted the effective administration of the school. For example, if there were instances and patterns of behavior where the assistant principal did not inform the principal about significant incidents in a timely or appropriate manner, the principal may argue that this failure undermines the necessary trust and open lines of communication required for the school's leadership team to function effectively. Similarly, if there were misunderstandings or miscommunications that led to problems in the school or its community, this could be seen as justifying a need for change in staff assignments to ensure the school's operation. By categorizing the request for transfer as based on those non-retaliatory reasons, the court indicates that the school principal's transfer request was motivated by legitimate administrative concerns rather than a desire to retaliate against the assistant principal for making a sexual assault report. However, for such a justification to hold, the principal would need to have documented evidence or examples of the communication and the trust issue cited, demonstrating a pattern or serious incidents that could reasonably lead to decision to request a transfer. In this case, the evidence could include not only the handling of the reported sexual assault, but also any other situations where the principal felt that the assistant principal's action or inaction compromised the safety or operation of the school. Third, regarding the letter of concern, the court recognized this action as potentially having a significant negative impact on the assistant principal's employment situation, classifying it as materially adverse. Despite this, the court concluded that the motivation behind issuing the letter were grounded in legitimate administrative concerns rather than an intent to retaliate. The primary issues cited in the letter involved the assistant principal's approach to managing some incidents in the school and her failure to directly consult with the school principal as the situation warranted. For the assistant principal, she could have moved forward constructively by taking concrete steps to show that she has taken the principal's feedback to heart. This could mean proactively seeking clarification on the protocols and expectations from the principal and other administrative authorities, demonstrating a clear commitment to following those guidelines in her day-to-day responsibilities. Moreover, she could initiate regular check-ins with the principal to ensure alignment on key issues and decisions, thereby preemptively addressing any concerns about communication gaps. On the other hand, for the school principal, this situation underscores the importance of providing feedback in a manner that is not only clear and direct, but also conducive to professional growth. Ensuring that criticisms are paired with specific actionable advice on how to improve would make it easier for the assistant principal to address the issues raised. Moreover, establishing a more structured framework for decision-making and incident reporting would help prevent similar issues in the future. By setting clear expectations for when and how the assistant principal should report incidents or consult with him, the school principal could create a more predictable and effective working relationship. Moreover, engaging in a dialogue about the concerns raised in the letter of concern rather than one-sided communication. In Harper Simon's book, Administrative Behavior, he argued that the function of the communication, after all, it's not to get something off the mind of the person transmitting it, but to get something into the mind and actions of the person receiving it. In this case, the school principal's communication patterns, including emails and the letter of concern, appear to be overly top-down without inviting or considering input from the assistant principal. Effective communication, especially in complex situations involving performance and conduct, benefits from being a two-way street. It should allow for clarification, explanation, and mutual understanding to emerge from the exchange. The school principal's communications appear to be centered around his own observation, interpretations, and the decisions regarding the assistant principal's actions. Well, it is within the principal's purview to guide and make decisions. Communications that solely focus on the sender's perspective can miss the opportunity to engage the recipient in a meaningful way and to understand the recipient's intentions, reasoning, and the challenges faced, which may have contributed to the situation at hand. When the school principal's feedback is delivered in a manner that feels unilateral and does not actively engage the recipient, it can be perceived as punitive rather than constructive. One more thing. In this case, the assistant principal also complained about the school district's handling of the situation, particularly pointing out procedural irregularities and the school district's deviation from its established policies when issuing the letter of concern. Those allegations suggest that the process leading up to the letter may not have adhered to the standard procedures outlined in the school district's own guidelines, which could include steps like formal warnings, opportunities for the employee to respond, or specific protocols for documenting and addressing performance issues. However, the court determined that while there might have been lapses in following procedural norms or adhering strictly to policy, the mere fact that an employee failed to follow its own internal procedures does not necessarily suggest that the employer was motivated by illegal retaliatory intent or that the substantive reasons given by the employer for its employment decision were pretextual. The assistant principal fell short in connecting those lapses directly to an argument that the principal's stated reason for the letter were merely a cover for retaliatory intent, what the law refers to as being pretextual. The assistant principal needed to provide evidence or reasoning that those procedural irregularities were not just mistakes or oversights, but rather deliberate actions intended to mask retaliatory motives against her for previous actions, such as reporting the sexual assault. For example, if the school district typically requires a series of documented meetings or interventions before issuing a formal letter of concern, and this did not occur in her case, the assistant principal would need to show that this departure from protocol was specifically designed to target her unfairly. This could involve demonstrating a pattern of similar situations where the district followed its policies except in cases where individuals had engaged in protective activities, thereby suggesting a retaliatory motive. The protective activities include reporting discrimination, filing a complaint of sexual harassment, participating in an investigation of workplace misconduct, whistleblowing on illegal practices, or asserting rights under employment laws such as taking family and medical leave or requesting reasonable accommodation for disabilities. The court's conclusion implies that proving retaliation requires more than just showing that mistakes were made or that procedures were not perfectly followed. It requires a clear demonstration that those procedural lapses were used systematically to disguise retaliatory actions. Without establishing this critical connection, the procedural concerns raised by the assistant principal, though valid, were not sufficient to substantiate claims of retaliation in the eyes of the court. What can administrators learn from this case? First, gather comparative evidence. If defending against claims of retaliation, you gather evidence that shows a pattern of administrative decisions that applies equally to all employees, irrespective of their engagement in protected activities. Look through past disciplinary actions, performance evaluations, and administrative decisions to identify cases similar to the current situation. For example, if a policy stipulates that employees who are late more than 3 times in a month are subjected to disciplinary action, show records of all employees who met this criterion and the actions taken, illustrating that the policy is enforced uniformly. If an employee is claiming retaliation after being demoted for poor performance, you find other instances where employees with similar performance issues were also demoted or face similar consequences, regardless of whether they had filed a complaint or engaged in any other protected activity. If applicable, you present evidence that shows a consistent application of policies not just across the personnel, but also over time. This is particularly relevant if organizational policies or leadership have changed, demonstrating that the same actions were taken under different management teams or policy frameworks can further support the argument that the actions are based on policy rather than retaliation. Second, establish a clear chain of communication. In cases where procedural lapses are identified, you, as an administrator, document any effort made to address those lapses or clarify procedures. For example, if an employee was disciplined without a prior warning, contrary to the usual policy, the acknowledgement can be a formal letter from HR or the supervisor explaining the oversight. You should also offer a thorough explanation of why the lapse occurred. You can describe the circumstances that led to the oversight, such as misunderstanding of the policy requirement or errors in judgment under unusual circumstances. For example, if a procedural step was skipped because it was mistakenly believed to be optional for certain cases, clearly state this in the communication. You should also clearly document the steps being taken to correct the procedural lapse. You can reverse or amend the decision based on the lapse, such as revoking an unwarranted disciplinary action or implementing additional training sessions for staff to prevent similar mistakes. Moreover, you detail any change or improvements being made to prevent the reoccurrence of similar lapses. This could involve updating the procedural manuals or introducing new checks and balances in the decision-making process. Document all communications related to addressing the procedural lapse, including emails, meeting notes, policy updates, and feedback received from staff. This not only serves as a record of your response to the lapse, but also demonstrates your commitment to the procedural integrity and the continuous improvement. Third, record justifications for actions, particularly for those decisions that had negative impact on employees. You need to explicitly connect your decision to the specific organizational policies that support it. For example, if an employee is being put on a performance improvement plan, the documentation should reference the specific performance metrics or standards outlined in the employee handbook that the employee failed to meet. If the decision is related to disciplinary action, ensure that all incidents leading to this decision are thoroughly documented. This documentation should include dates, times, description of the incident, any witnesses, and the previous steps taken in response, such as warnings or corrective actions. For example, if an employee is being suspended for repeated tardiness, the documentation should list all the instances of tardiness, any warnings given, and how those actions violate the organization's attendance policy. Your decisions must be backed by evidence. If an employee is not considered for promotion, the decision document should include references to their most recent performance evaluations that highlight areas of concern or aspects of performance that do not meet the promotion criteria, such as leadership skills or project management abilities. The reason that the court ruled in favor of the school district, not because the school principal did everything right, but because the assistant principal did not provide sufficient evidence to prove that the actions taken by the school principal was motivated by the retaliatory intent. To avoid being accused of retaliation, administrators should engage in practices that emphasize fairness, transparency, and consistency. And this includes clearly documenting all employment decisions and their justifications, ensuring those decisions align with established organizational policies, and applying those policies uniformly across all employees. Open communication channels should be mandated, allowing for feedback and dialogue. And any disciplinary actions or performance evaluations should be based on objective criteria and thoroughly documented evidence. This approach not only helps in defending against potential legal challenges, but also contributes to a culture of trust and respect in the organization.